Welcome back to the channel. I am the Black Belt Barrister, and this talk is on charities and fiduciary duties, and addressing some of the questions that have come up in recent videos to do with the collection of money for charity and the responsibilities of trustees, such as to avoid conflicts of interest and things like this. So I thought I would go through a little bit of the law, a few of the terms, and try to explain some of this for you. So the fundamental and underlying principle behind all charities is what is referred to as a fiduciary duty, which I'm going to explain if you're not familiar with the term. So if you are a trustee, it means that you are trusted to be responsible for something, to act solely for the benefit of the beneficiary. So fiduciary duty means there is a fundamental duty to put the interests of the organization or the beneficiary for whom you act as a trustee before your own. And a fiduciary duty allows for no room for any kind of self-interest whatsoever. This is one of the oldest laws, and it's one of the most fiercely defended and protected laws in the United Kingdom. A fiduciary duty will include the responsibility not to act unfairly whilst holding that position, not to act in competition, and even after leaving the position, not doing anything that is going to damage that which the fiduciary was protecting in the first place. So with that in mind, let's move on to a little bit of a discussion about charities, how they operate, who must register, what the rules are for collecting money, what must be done with that money, because many of you have asked questions about how this money is handled, collected, who must register a charity, and so on. So first of all, linking the idea with this fiduciary responsibility with a charity, it is the overriding duty of all charity trustees to act in the very best interests of that charity. And as the rules are very slightly different in England and Wales as against Scotland and Northern Ireland, this is primarily talking about England and Wales because there are some special rules that apply to Scotland, but you can find those on official websites anyway. So for England and Wales, there is a charity commission and there is a charity governance code. And indeed, there is a code of fundraising practice, all of which I'm going to refer to throughout this video. So going right back to basics and when you must set up a charity, well, if you are acting in charitable causes and you have an income of at least £5,000 per year, or it is what's known as a charitable incorporated organisation, which is essentially a company but acting for charitable causes, and it's based in England and Wales because this is what I'm focusing on in this video, then either of those apply. It must be registered with the Charity Commission. And the law that sets this out is the Charities Act of 2011, Section 30, specifically subsection 2D. Charities whose gross income does not exceed £5,000 does not need to be registered, but otherwise every other charity must be registered in the register. So I will come on in due course to the interplay between registered charities and volunteers and professional fundraisers, because the rules get a little bit complicated and the relationship is quite complex itself. But sticking with the principle of a charity, first of all, once a charity is registered, it will have trustees. Those are the individuals who are to look after the charity's interests, look after the charity's money, and they have a duty to take steps to make sure that the charity's money is safe, properly used, and indeed accounted for. It's important to remember that every single trustee must do this, even if they have professionals who are, let's say, auditing the accounts and so on. It is still the responsibility of the trustees to ensure that that money is safe. And upon setup, the charity should have a governing document and relative policies, and the trustees must make sure that all of the money is only spent on what is allowed within those governing documents and policies. So once the charity is set up, then the individuals need to go about trying to fundraise and actually bring money in. Now, it's all very well for those large, well-established charities to do this by way of a name for themselves, but new charities that are trying to start to raise money will obviously have to seek out volunteers or professional fundraisers, or in some cases consultants. However, there are various laws in place that make it a requirement for those trustees to manage and supervise those fundraisers, whichever category they fall into, which I will come back to in a few moments. But ultimately, those trustees must, by law, have overall responsibility for the fundraising activities on behalf of the charitable organisation. And this includes if they've delegated any of those responsibilities or any of the fundraising activities. And as I said at the outset, that includes acting in the charity's best interests, and most importantly, being aware of any possible conflicts of interests between the duties owed to the charitable organisation and any loyalties had to others or interests, or particularly financial interests, in other entities. And so moving on to the subject of fundraisers, it must be made clear by law to all fundraisers that all of the money must be received by the charitable organisation without any deductions. There are a few exceptions, but as I said, I will come back to those. And interestingly enough, some people have asked questions about having donations refused or asking for donations to be refunded. Well, trustees must not refuse or return donations except in very exceptional circumstances. If a decision is taken to refuse or refund any donation, then a record of both the refusal, the details, and the reasons for it must be kept. There must also be due diligence carried out on the size and the nature of any donation, because this naturally will affect the financial and reputational aspects of the charitable organisation. So now talking specifically about the fundraisers, as I said, they can either be volunteer fundraisers or they can be professional fundraisers. If the volunteers are to be working with children or with vulnerable adults, then the charitable organisation can, by law, get a DBS, a Disclosure and Barring Service check, which used to be known as the Criminal Records Bureau check. But it's important to note that the legal status of volunteers must be absolutely clear, and this should probably involve a written explanation of what they are doing, because otherwise there might be questions as to whether they could be considered an employee and therefore have various rights as an employee. As for expenses, well, volunteers cannot and should not be paid for their time, but they can be paid expenses for their travel, postage and telephone costs, and essential equipment only. Any other payments apart from expenses not only would raise questions as to whether they are part of some kind of salary, maybe giving them employment rights, but also might bring the trustees into disrepute for not treating all of the money as it was intended to be collected in the first place. When it comes to paying fundraisers as professional fundraisers, they must not be paid excessive amounts. It must be reasonable, sensible, and proportionate for the interests of the charity in question. In these kind of scenarios, there must also be systems in place for managing the performance, recognizing the effects of the payments to the professional fundraiser, and it's important to note that commission payments must not be used unless all other avenues have been exhausted. And an important distinction that cuts across all of these is if the individual is a charity trustee, then they must not be paid for their fundraising activities unless they meet very specific conditions depending on the country they are in. Moving on to some clarifications for professional fundraisers, if they are carrying out a public charitable collection and are paid more than £10 per day or more than £1,000 per year, but are not a professional fundraiser, then they must make a statement to the effect of the name of the charitable institution or institutions that will benefit from those donations, if there is more than one, fact as to whether or not they are an officer, employee, or member of a governing body or charitable institution, and whether or not they are receiving any kind of payment or acting as a collector. When it comes to the collections themselves, there is a very detailed document called the Code of Fundraising Practice released by the fundraising regulator. Now, most collections are going to be way of cash, although many of them are by direct debit, cards, and so on, and this document covers all of them. But covering cash in the first instance, again, many of these terms have the word must in them, which in a legal sense usually means there is a law behind it and it is a legal requirement. So first of all, cash must not be left unsecured or unattended. Also, all cash that is collected must be counted and recorded by two unrelated people if at all possible. It is also a requirement that cash donations are placed in a sealed container or a collection box. Furthermore, the fundraiser must also ensure that the promoter, which is typically the charity's fundraising manager, and another responsible person or a bank official are present when opening and examining collection boxes. This applies to all public places, and if the collections happen on private land and it's not practical to open the collection boxes, then there must be effective procedures and instructions for the person who owns or manages the site to count, record, and bank and deliver that money that's inside the boxes. Finally, all money must be banked as soon as possible and being stored in the interim securely, and the money banked and receipts against it must match the income summaries as against the money that's been counted. And if at all possible, it should be someone that wasn't involved in the counting of the money or the cashing up of the money who must ensure that these two sums match. In the event that sealed containers or collection boxes are not used and opened and counted in the way that I've just described, then receipts must be issued for all donations which are to be signed against the donated amount. And there are, of course, additional rules in respect of giving checks. Moving on to a slightly different area, some collectors will be working on a basis of collecting money in aid of another charity. These are called in aid of volunteers or in aid of collectors. You'll typically hear the phrase that they are collecting money in aid of XYZ charity. For any organisation managing such collections, they should be aware of the responsibilities under Part 2 of the Charities Act 1992 and Part 2 of the Charities and Trustee Investment Scotland Act of 2005. These are fairly extensive, but in brief, it involves a letter, certificate or badge that contains various information identifying them as a collector, and it identifies any organisations either carrying out or benefiting from that collection. Such information should include the collector's name, contact details of the third-party fundraiser, name and contact details of the charitable organisation benefiting from the collection, and of course there are a list of other requirements. It's important to note that it is against the law for any commercial participator to claim as part of any kind of promotional venture that they're going to give money as a charitable institution unless the claim is in line with a written agreement that they have in place with that charitable institution that they're raising money for. This agreement must be in writing, and it must be signed by or on behalf of both the commercial participator and the charitable institution. So you can see by the detail in this video that I've barely scratched the surface of the law, the regulations, the requirements, the pitfalls, the duties and responsibilities to all those involved with running a charity, being the trustee of a charity, collecting for a charity, and so on. And I can only sum up the video by repeating what a very senior Chancery barrister, now judge, once told me, which was, never get involved with running a charity in any way, shape or form unless you are in for a great deal of detail, complications and regulations. So I hope that served to address some of your questions, so please leave any other questions in the comments box below. Please remember to subscribe and like the video, and thank you for watching.